Artificial Intelligence Law and Justice course, session 12, 1 and 2 of the topic Algorithmic Justice. Recap. In the last session, that is the third session which we had, among the three, we discussed about AI's impact on the rule of law and how it raises lots of concerns and then what are the ways to address them. In particular, we stressed the need to address the issues in accountability as well as care for regulation of AI with the rule of law as a consideration. We pointed out that addressing these challenges requires upholding the rule of law through human involvement and possibly enforcing an obligation for its explainability. In the sense that we had a look at how AI can impact the idea of rule of law in both theory and practice and what are the implications of that. In particular, when there are issues like AI can adversely affect the basic principles of rule of law when applied to day-to-day practices. So, in that one, we looked more from a very rule of law angle perspective, particularly how AI systems can affect. In this session, we are going to look at another concept, which is very interesting concept, an evolving concept called algorithmic justice. We all know about justice, but we have also discussed about algorithms, particularly algorithmic decision making. So if we can connect with what we have already read or already taught in algorithm decision making, algorithmic justice is a sequential to that or is something that can be derived from that. So we need to define what is algorithmic justice. Algorithmic justice is an emerging and new concept and it is linked with the larger issue of fairness, justice and equality in the context of AI. So algorithmic decision making and then technologies like facial recognition technology. We should keep in mind that when we talk of algorithmic justice, we are not talking about mere algorithmic decision making in some sectors or in some specific examples or some application. We are talking of a broader one wherever algorithms are being used, including facial recognition technology, and then how that decision making can impact adversely people's rights and their entitlements. It can be considered as a ruthless critique, but it goes beyond that. For example, the Berkeley Center for Internet Society, Harvard University, is also working on algorithmic justice, but then the way work is not just critique. They also work with companies, they also work with other stakeholders to ensure that algorithmic justice is not something that remains as a mere negative critique, but they do a lot of work on the making things better. So the criticism from algorithmic justice are not there just for the sake of criticism. Many of them are in fact expressed with a lot of concern about rule of law, fairness, due process, and then what every legal person will tell that the fundamental issues which the law has to be dealt with, or the fundamental issues where the legal principles have to be applied without any exception. So having said that, let us also look at how it emerged. This idea of algorithmic justice is not very old, it's quite new. In fact, it's not even a decade old. This was popularized by Dr. Joy Buolamwini, whose experiences with facial recognition technology showed that technology applications were biased and her face was not recognized only when she wore a white mask. See, the problem was she was a scientist, she was educated in Caltech, Georgia Tech, but then she faced a unique problem. The facial recognition technologies did not recognize her face at all, but they recognized only when she wore a white mask. So she did an in-depth research and then found out that the problem was the AI algorithms or the algorithms which were used to train the facial recognition technologies were simply biased. So she wrote a fascinating book called Unmasking AI and also founded an Algorithmic Justice League. It's an NGO. And then her work can be viewed in Coded Bias, which is also available on Netflix. So she started describing about algorithmic justice, but in the sense that she made it very popular, but then the discussions about algorithm, unfairness, accountability, reasonableness have been there for quite some time now, at least for a decade, in the legal literature and administrative law and elsewhere. We can have a crisp definition of algorithmic justice, the application of principles of social justice and applied ethics in the design, deployment, regulation, ongoing use of algorithmic systems so that the potential for harm is reduced. So algorithmic justice looks at the potential for harm and tries to mitigate it or minimize it. At the same time, algorithmic justice is a very broad one. It is not focused on any discrimination or bias against a single group, and then it is not focused on any single technology. So it is technology neutral. In that sense, algorithmic justice can be expanded to or applied to wherever, irrespective of application or systems, algorithms are used for decision making, in particular in criminal justice system and everywhere else. So this concept is an emerging one which has got huge application on account of the algorithmic decision making being more and more popular and widespread. When we talk of algorithmic justice, there should be a counter concept called algorithmic reparations. So, drawing from the intersectionality critical social theory, Davis, Williams and argue that we must name, unmask and undo allocative and representational harms as they materialize in the social technical form. So they suggest that algorithmic representation as a foundation for building, evaluating and when necessary omitting the era. But the problem here is that algorithmic reparation is not a well known concept. It's not well accepted in the sense that not many people have worked on it, but it's a very interesting concept. But we are going to focus only on algorithmic justice here for the simple reason doing a course discussion with algorithmic representation is not part of the syllabus. Two, again algorithmic representation is not very much discussed in the literature. And then the third most important point is that the very idea of algorithmic representations is not fully developed in the sense that now we can elaborately discuss it in a course like that. So having seen the origins and definitions, we should see why are we looking at it. Are we talking of algorithmic justice only in the context of law and justice? No, because algorithms are being used in many disciplines, many applications including AI in healthcare, AI in medicine, AI in diagnostics, AI in education and all. So we may think that idea of algorithmic justice or AJ is applicable only in some sector. It is not that. So the context and the stakeholders will vary, and then the idea of addressing algorithmic justice will remain the same. For example, in a report on algorithmic justice in precision medicine, it was suggested train model developers and users on health equity and health justice frameworks, the profound impacts of health and health care disparities on individuals, communities, decision-making trade-offs and their impacts. You might remember that in my earlier classes I had also mentioned that how the problematic assumptions in algorithmic training, which is based on merely doing for healthcare applications or diagnostic on selected population, and then the problem of leaving out certain population clinical trials. So in a wider thing, even in health, we need to look at the scope for algorithmic justice. It is essential to determine how algorithms can be used to uncover biases in the databases, algorithms and the related systems, and how algorithms can preclude such bias in establishing future databases. So this idea of algorithmic justice being used is taking something like, you are using algorithms to find what is going wrong with algorithms, and then you are using algorithms to make things better. So this report towards algorithmic justice in precision medicine from the University of California, San Francisco was published in 2024. It was based on a proceedings of a meeting, but it does has a lot of interesting information on the application of algorithmic justice in medicine, particularly in precision medicine. A key theoretician in this field is Professor Karen Young. She has written extensively on algorithmic justice, algorithms in administrative law, and more importantly on technology and regulation. So we will be citing her work often in this course, in this session and the next one, for the simple reason that she is a pioneer, and more importantly, her observations have been very acute, to the point, and they have stirred a lot of debates, in the sense that how do we address this question. So to begin with, her idea is, we argue that algorithmic quality also demands adherence to constitutional principles and legal requirement, at least for tools intended to inform public authority decisions. In these application domains, constitutional principles, administrative doctrines, human rights norms are a crucial part of the relevant social technical context and must therefore inform and constrain the exercise of decision-making authority by criminal justice officials. Which means that algorithmic justice also is concerned about how decision making by the authorities will be based on algorithms and then algorithmic decision making. Her point is much more than this. Her point is that whatever we think as a technical design choices, when they are building into algorithm and making tools for criminal justice, create constitutional dangers. So, in other words, what you think as a technical choice and then technical solution, and then built by the experts, algorithm, people who develop the algorithm systems and others, can have larger implications on constitutional rights. However, the fundamental problem is more acute than this because we cannot simply address algorithmic justice as a technical problem, and the moment we know, we look at the root cause of this and then say, oh, the problem is that those designed those technical systems were not aware of it, and then they made some technical choices, they are not in the right spirit, not in the right sense. So these could be rectified, and when we can move towards a perfect, technically perfect, and then solutions that are also constitutionally rights enforcing. That is one way to look at it. How far that is feasible again is not a very general answer because it's something that depends from context to context, application to application, the target group to target group. So the potential for that such a remedy is still there, but the point we need to move on is that why are we talking of this, particularly in the context of criminal justice system, is that very simple one. There are technical solutions, then there are individuals like us. According to Janus, Christian, Verbung and Jacob Bush, they make a very interesting point. Constitution does not recognize us as numerically derived persons or data or an agglomeration or a consolidation of some data picked up from here and there. Or in other words, my body is not a combination or a bundle of all the tissues, bones and everything. It is much more than that. So when we talk of bodily integrity, when we talk of a body in the context of health, we refer to the whole. We are not talking of a bundle, we are not talking of a consolidation like that. So constitutional rights recognizes that individuals, not as a representation of XYZ data put in XYZ medium. Algorithmic representation, the problem is on the other hand, it gives no special attention to our biological, psychological and narrative properties, and as such they fail to capture the central aspects of our ordinary representation as human identity. Put it in other words, can my identity be reduced to some set of data and then data certified or data analyzed by some certain parameters and then pushed further? Or can I be reduced to a tiny speck in a big data? Or can my identity be defined and understood as something that is totally based on data? No, we cannot. Indeed, we have argued algorithms make predictions about us relying on properties that do not directly relate to or reflect the individuals we understand and represent ourselves as being. So when I stand in a court as a lawyer or as a witness or as in any other capacity, I do not represent myself in terms of my data. I do not represent myself in terms of my bank account number or my Aadhaar number or anything. I stand before the court or any authority or in any legal sense as a person, as an individual. Whereas the problem with the algorithm solutions and then most of the AI system is that they reduce all this to some data analytics, to some probabilities, and then to make some conjectures and then calculations and then to arrive at a decision. So I am not a mere combination of certain parameters, certain data to be decided by algorithm. So if I can consider myself as an individual, not as a statistical individual, then I will also look at what exactly the technical solutions are looking at me. I look at algorithm as a way to do certain things, but algorithms looks at me not an individual. It looks at me as a statistical individual. So when that looks at me as a statistical individual, the idea that I am a human being and then I do have some rights, or in other words, we don't represent ourselves as we are not as statistical information but as persons. In other words, we can also say that cannot be reduced to mere statistical data or statistical inferences like that. If a person may be sick, but then that doesn't mean that you will reduce that person to some health parameters and then declare that this person is equivalent to these health parameters, health data, like we can't do that. But let us also understand one more thing. Some of the biases we are talking of or accusing of algorithmic systems are not new. They have been there earlier. Humans have are prone to have some biases, and some of them are well known. So we have found some ways and means to address them with mechanisms to curb arbitrary excess of power based on the bias and prejudices. That is why the legal system, you have appeal, you have due process, then you have the processes to establish certain things, where the court or the judicial process itself will tell you what to do and what not to do. But the processes are done in such a way that equality is built in, biases are tried to be eliminated, or more importantly, they cannot be something that is an arbitrary excess of power. So, problem here is that biases can be contained, biases can be tackled by making transparent, systematic, open systems where people would know what exactly they are being represented as, so that that bias angle can be tackled. And by denying excessive authority or arbitrary excess of power to anyone, including the judicial system, we can try to curtail, if not fully eliminate, the biases. So we know how to deal with the old biases within courts, but we don't know how to deal with the new biases arising from algorithms. So the problem here is that machine learning algorithms, human bias which is already there, is put in a different shade, is also added to that, and then it is getting in the layers and layers of the mathematical code and computation, but it is often considered as objective, not that is not based on bias, and then it is very difficult to really spot and challenge, in the sense that unless you know how the algorithms work, unless you have the expertise to understand the inbuilt algorithm that could be explicit, or the implicit algorithm where the bias is not implicit but it is showing in the outputs. So this is a question of opacity and technical complexity. One, opacity is something equivalent to what we have already discussed about black boxes. Technical complexity is that as layers and layers of code are being added, as algorithms do things in multiple iterations, particularly processing data from different sources and also for different purposes with different objectives, the technical complexity of the system becomes more acute. Now you need to take in the information asymmetries. So the information asymmetries are something like that when it occurs, particularly when a software solution or a software system knows more about me or has a better idea about me than myself when it comes to certain circumstances. So the information asymmetry between the algorithmic AI system, which has enormous data on me or anyone, versus me, who doesn't even know or who won't even know that so much data is available with an algorithm for its processing and then for assessing me. So this is an information asymmetry. So we are seeing three factors here: opacity, technical complexity, and then information asymmetry. So when these things combine with algorithmic decision making, we need to be really worried about. Further, an important fact is that models are not tested on human beings, models are tested on data, models learn from data, models perform analysis and then come with the output. That they may make mistakes, they may get corrected, better algorithms can be built, better data can be fed, and then the whole process can be iterated till the quality control norms are being met, or the potential for its error is also being reduced. But the reality is little different. When you test a model, when you are running it, it is not something that is equivalent to real life circumstances. So the real life circumstances where they are applied, where people in flesh and are there, or where the living persons are there, is totally different. Although you can say that everyone is a criminal and every criminal is a criminal, it is not so. Each criminal cannot be reduced to the bundle of, oh, they are all criminals, and then put a label that everybody in this they are criminals. It is not. Law doesn't look like that. Law does not look people as in such classification of these are criminals like that. It gives an opportunity for an individual to defend himself or herself as an individual. But the problem here is that when we try to overlay on these technical black boxes, we are also trying to reduce meaningful human involvement and intervention. And this particularly happens the models that are tested on test data made better deal with or have to deal with real life circumstances where people with whom they are dealing don't even know that the systems are dealing with them in the way which is an opaque to them. So the irony is that system is something like a black box, or it is something like a camera that can always watch you or that can always detect you, but you will be clueless about how the system works. Professor Karen again points out it is presumed innocent till you are proved guilty in criminal justice. Or in other words, until and unless a person is finally convicted after exhausting all the appeals, that person will not be considered as a criminal. So, till the final verdict comes, you are claimed to be or you are deemed to be innocent. But then the criminal system, just a system when it is using algorithmic decision making, type 1 error can happen. In that sense, it can falsely convict an innocent person. The type 2 error is it can also let the guilty go. So there are two possibilities here. One, an innocent person may be wrongly convicted. Two, a person who is really guilty can be let go or can be freed or can be acquitted. Now the problem here is that type 2 errors are less severe in the sense that we are letting the guilty to go. But punishing the innocent is a much more serious error. So type 1 error is much more serious than type 2 error, although we can find ways and means to ensure that type 2 error doesn't recur. So those who do this, should they be held accountable? Yes, they must be accountable. Which means that there should be a right to due process, and then the due process should be applied. Now the problem here is that the risk of type 2 error can go for typical due process, because often courts acquit a criminal based on lack of evidence or not fully satisfied by the court, although in reality that person would have been the one who is guilty. But it can minimize type 1 error, although increase the risk of type 2 error. So that's a trade-off here. Still we go by the criminal justice system because of the thing that it is better not to punish an innocent than to do other way around. Or an innocent person should not be punished under any circumstances, even if there is a possibility that a guilty person can get acquitted. The problem which she and many others have pointed out is that the algorithmic decision making tools do not take into account this type 1 error and versus type 2 error, punishing the innocent versus letting the guilty go in the criminal justice system. So the implications are these systems cannot be a substitute for due process based decision making, because the idea is not at all there. And then depending upon the context of use and the decision given, their impact will vary. In the sense that if used on a mass scale, it is potential that lot of innocents will get punished when we do ADM where these problems are there, but they are not taken into account. So they could exacerbate more of type 1 error, and then they may not give that much of type 2 error. So we should, criminal justice system, through its appeals through the due process and by opening up so many options for anyone to prove he or she is innocent, makes sure that the innocent person are not convicted at all. But here comes a catch. When we thoughtlessly apply ADM in all the setting, whether it is right solution or not, rights will be violated directly or indirectly. It can happen in facial recognition technology, it can happen in public service, it can happen in criminal justice system, it can happen in bail and thing for those who are in the jail, like that. But we cannot simply equate that and say that all ADMs are equally bad or all ADM applications are equally terrible. No. See, when Netflix or Amazon or any recommended system tells me to watch something or to buy something or to consume something, it does based upon my browsing data, my visit of to various websites, my previous purchases, or the YouTube ones where what all I have seen in YouTube, and then other things. In the sense that my browsing data is being collected, my purchase data is being collected, and then the recommender system comes up with some options to you. Okay, buy this, have a look at it. Since you have bought this, we can also try this. Maybe recommend it. But recommending by Netflix, Amazon or Google is not the same as someone judging through a algorithmic decision making. So the former, however problematic we may feel or however irritating it could be, is not the same with the later. Because the later is much more severe, potential for harm is much more than the anything else. So question here is that should algorithmic decision making have a place in the criminal justice system at all? Or should we say that efficiency versus rights and transparency is a trade-off which we have to live with? Because algorithmic decision making systems, despite all the problems, are better solutions in criminal justice system. So who would decide what is the efficient solution, the right solution, and then what is the level of efficiency? Can we say that an ADM which has got an efficient level of 70% is good enough that it can be applied across all the criminal justice system? Or will we say that we need a system that is more humane, or a system where the innocent will not get punished, or the innocent, even if they get punished, they will have an opportunity to prove themselves by going to a court of law and then trying to produce evidence to that effect. So decision making algorithms also context, purpose, and then who is impacted make a huge difference. So according to Professor Karen, algorithms do not harm people is a fallacy. This is something like guns do not harm people, people harm people. Or the agency in this argument is that with people, not with the guns. But the problem is that there is a huge difference between guns and an ADM. That is very obvious. So even if the tool does not, and in itself with the engaged human rights, it does not follow that we can ignore other kinds of forms like troubling tendency of digital enchantment of the contemporary policy discussion. To ignore ADM systems or powerful technologies which are capable of producing dangerous decisions, so the problem is that it's not that you need better decision making in the sense that better designs, benevolent developers, perfect exercise of a human discussion by a human decision maker, because the problem is that they have the capacity to automatically on scale and trigger action in that is remote both in time and space from the location where the action is triggered. So the ground truth or the ground reality is that however much we say that ADMs are very efficient and then they could be designed by people who are very sensitive to such biases, we can try to eliminate as much as possible all the biases within the data and training. Capacity to come up with a decision when it is there in ADM. So her point is, we may think that government databases, accumulation of databases, efficiency, linking databases, and then use of much and more of data in decision making, particularly in criminal decision making, is a good thing and that will enhance efficiency. That is the normal tendency to argue. But in her view, government by database is much more threatening to human rights and democracy than a policeman with a pen and notebook. So don't underestimate the power of algorithms, don't underestimate the scope for misuse when algorithms are using databases. So her argument is that the fallacies we need to pay attention, and we cannot take the stand that guns per se are okay but problems are people. Here her argument is the exactly other way around. Guns per se are problematic. One of the ways these things have been discussed in the literature is through algorithmic accountability. So as persons like Karen have suggested, they have also suggested some measures like how do we counter that, solutions through human rights law, administrative law, use of judicial review principle and anti-discrimination principle. Some people have gone ahead and also said there should be data protection law and some of the other legal principles can be used. But the idea here is algorithmic accountability should be brought in, should be practiced, and more importantly, algorithmic accountability is not something that can be reduced to mere numbers. In the sense that we cannot say an algorithmic system that is 90% error free, which has got error only in 10%, is good because 90% error free is perfect. Because what we need to pay attention, where the 10% margin of error occurs, whom it will impact, and then how it will impact. So the algorithmic accountability is something that need to look beyond the number crunching systems and then the numbers themselves. One of the ways people in the literature have been arguing about is that, okay, you all talk about all the problems in the ADM, you all talk about the algorithms deciding with bias and then discrimination, and then you all talk about these systems as dangerous monsters. So can't we make things better? One of the argument is that by lawyers working with developers of ADM can some of these. In the sense, when such systems are developed for specific application in criminal justice, employment, public welfare, there should be institutional mechanisms that build safeguards and guardrails in such systems. In the sense that the institutions which commission these ADMs or which procure these ADMs should have some idea as to how they can bring in safeguards and guardrails in the systems themselves, particularly when they are applied in critical systems like criminal justice, employment and public welfare. Is it possible to think of algorithmic decision making in a positive way and for social good? And then more importantly, given the widespread use of algorithmic decision making in public sector and private sector, who is going to assess them, who is going to control them, who is going to take a look at them and then decide we have had enough or the numbers is becoming too much to handle, so let us put an end to it. We will limit ADM only to some sectors. So in the next class we will discuss some of these. We will also look into some of the recent debates on ADM as well as some of the solutions. Thank you.